another thing, people give up hope, okay? And they go, well, my doctor isn't doing much. They're prescribing whatever, anti-inflammatories. Doctor's not listening to me. Doctor's not helping me. So forget it. I'm not going to the doc. I'm just going to stay home. And a lot of folks, will come to you and you look in the record and there's not much there. And what I do if I undertake a case in the early stages of representation is I say, you got to go to your doctor. You got to go and you got to say what's wrong. And I always tell them, I say, don't go there because it's happened where they go there and say, well, I'm here because my lawyer thinks I should go to the doctor to build up my disability case, right? That gets charted, right? You don't want to see that in the chart. That's not good. Okay. What I tell people is when you go to the doctor, come from a frame of mind of wanting to get better.
Right.
And the reason
Good morning, Bruce. How are you?
Good, Pete. How are you?
I'm great. Thanks for asking. Well, I'm appreciative of your time today. I know you've got a lot going on in your world, so thank you for sitting down with me. What I wanted to do this morning was just to ask you some questions and introduce you to not only the clients of Evan's Disability, but and maybe some potential clients out there, but also folks who might just want to pick up some knowledge about Social Security law along the way, or some tips here and there. But before we do all that, I'd like to start with just sort of kind of your background of, your legal background, where you started, maybe law school or college, and sort of walk us through kind of what you think might be relevant to that got us here today.
Absolutely. So I don't know how far back you want me to go. Very briefly, I grew up in the San Francisco East Bay area. I got my undergrad degree at California State University, Chico. I did a paralegal program there. Took a bunch of law classes as an undergrad in college, and did an internship actually in college in which we represented disability claimants.
Oh, wow.
Because look, an interesting fact about Social Security disability is that you actually don't have to be a lawyer to represent somebody in a Social Security hearing. So by the time I graduated from college, before starting law school, I had done about 40 disability hearings. So after graduating from Chico State, I went up to Eugene, Oregon for law school at the University of Oregon. Graduated and passed the bar in 1992. I've been an attorney since 1992. Right out of law school, I went to work for Oregon Legal Services, where I did exclusively SSI disability hearings. And after that, a couple of different private law firms, always doing disability cases. Started my own practice in 2002, continued, of course, doing the disability hearings. And at that time, I started doing my own federal court appeals. So I started to appeal the cases into the United States District Court, and less so, but also to the Ninth Circuit Court of Appeals. So that's a little bit about my background. Very conservatively, I've probably done 2,000 disability hearings.
Yeah, that's probably a really conservative number. I would guess, that's on the very, very low end. when you were doing working with these private law firms before you started your own firm, have you only done Social Security disability law in your career, or have you done other types of legal cases along the way?
I've also done, I worked at a firm that had a high volume workers' compensation practice. So we represented injured workers, or Oregon injured workers. And in that firm, I did hundreds of workers' comp hearings. We also did personal injury. So, car wrecks, slip and fall. We did some medical malpractice, some products liability, things of that nature. So I have experience, in administrative law with disability and workers' comp, and also civil, on the civil side with the injury work. And, that's involves depositions, trial work, and all of that.
With that rich experience of doing other areas of law outside of Social Security, what, if anything, from doing personal injury and, workman's comp and this, which is vastly different, because I've done a couple personal injury, quite a few personal injury cases.
Mm-hmm.
What skill set do you think you brought from that improved your representation within the Social Security world?
Well, so for folks that have never been to a Social Security disability hearing, one of the things that's interesting about it is, in that hearing, there's no attorney on the other side. There's a Social Security judge called an administrative law judge, but there's no actual attorney representing the government in a Social Security disability hearing. Unlike that, in the workers' compensation setting, and of course in civil litigation, there's a lawyer on the other side. And that lawyer is usually pretty smart and pretty experienced, and they are there to take your case apart. And so you essentially develop sort of a hypervigilance for identifying, the weaknesses in my case. Where's the weak link in the chain? And because in those settings, workers' comp and civil litigation, they're coming after your weak spots. So I have to identify them. I have to try to fix them. And so that practice, when you bring that over to the Social Security realm, you're looking at, okay, what sort of, I guess if you want to call it ammunition, what sort of ammunition is this judge going to use against my client? So it's kind of I think lawyers will tend to sometimes, we like to look at the strong aspects of our case, and of course we do that. We bring those up and we bring those out, but we also have to look at, where are those weak links, and what can I do to bolster my case in light of the weaknesses? And that was just a crucial function in the civil and the workers' comp settings, because they're going to come after your weaknesses. So you need to identify those and do your best to fix those.
Right. And it prepares you to respond, as you can, if you know where the weakness is in your case, it allows you to prepare on how to respond to that weakness, versus just being blindsided. And I think,
Exactly.
Right. So my experience with Social Security judges is that they may see a weakness in your case, And because of your rich experience with doing civil litigation and workman's comp and, PI or personal injury and whatnot, it's brought that skill set of being able to really be prepared for a case. And you're able to respond to a judge if they're like, hey, Mr. Brewer, what about ABC in your client's file? And well, you can say, you know what, Judge, great, because I was going to bring up ABC, and here's response to ABC is, XYZ. And so I think that's a great skill set that I think if a young attorney only ever does Social Security law and doesn't have any experience outside of that adversary of someone who's really going to pick your case apart, you don't get that skill set of preparing a file in that way.
That is exactly correct, because the nature of, a Social Security hearing, for clients, it does feel like a formal proceeding. They're administered an oath, and they're questioned, much like questioning goes on in a TV courtroom type thing. So for clients, it doesn't feel like an informal proceeding, but technically disability hearing is an informal proceeding. The formal rules of evidence don't apply to it. And so I think lawyers will get a little relaxed because of that. And you have to, you have to identify the weaknesses in the case, and you have to, sort of do an end run around those. And sort of along those lines, the other thing that I'm doing in a Social Security disability hearing, because, judges deny cases, right? I want a good appeal. I want a good, solid appeal record. So not only am I putting on testimony to win that case in front of the Social Security judge, but I'm also doing things that, are based on my knowledge of the Ninth Circuit case law as that applies to disability. And so I'm asking certain questions that are going to, create a good appeal, that are going to kind of protect us on appeal. And that kind of goes hand in hand also with recognizing the weaknesses and addressing the weaknesses as well. Right.
And you're saying the Ninth Circuit Court of Appeals primarily because, you're based, you're licensed in Oregon and do a lot of federal court work in Oregon. But across the country, there's other circuits that, like we have the 8th Circuit and the 7th Circuit. And as we're now kind of expanding into places like Texas and Louisiana and pushing east, that circuit court law would apply to that circuit court. So Ninth Circuit isn't just nationwide. We're kind of focused here, or at least your federal court practice has been focused in Oregon specifically. But one of the questions, and if you'll just give me a second to kind of walk this through for folks. In Social Security world, there's basically 4 steps. You have the application, reconsideration, the hearing, and the appeals council. And you can drop that into one big box. Technically, after you're denied at the appeals council, which is the final appeal within the Social Security Administration, technically right, all your appeals have been exhausted. Right. And that's all done because the Social Security Administration is run by the executive branch, and even the judges are executive branch judges. That's all been done through the Social Security Administration. Because I've never looked at a judge's paycheck, but it comes from the Social Security Administration. Right. One of the great unique skills you have, and not every Social Security attorney does this, but there are a handful of lawyers. You do it, I do it. We have some folks in we know a bunch of folks that do it, but not every Social Security attorney does this, is that there's another branch of government, the judicial branch, that has 3 steps along the way as well. United States District Court, the Court of Appeals, and obviously, the Supreme Court of the United States.
Right.
And your skill set, and one of the things that I love about your mind and your experience, is you've done hundreds, if not thousands, of United States District Court appeals. And I don't know the number, and you can share that if you'd like, if you know. And even up
over 300.
Yeah. And even up to the Circuit Court of Appeals, which is based out of San Francisco, covers, this section of the United States, at least the West Coast of the United States. But that's a whole separate skill set, because it's not handled like a Social Security hearing. And, the going into federal court. So first, let me ask you this. How long have you been doing Social Security hearings only work? And then when did you start doing federal court work?
Well, as I mentioned, I did so I started doing Social Security disability hearings in 1987. And at various times throughout my career, I had, a high volume hearings practice, and I tended to refer my appeals to federal court specialists. In 2002, I started doing my own federal court appeals. So I have about 20 years, little over 20 years experience doing federal court appeals, and a lot longer than that doing the hearings.
And maybe just at a very Mount Everest view at federal court work, what is the distinction between a Social Security case at the Social Security Administration and, you taking a case to federal court?
One of the big differences is that, and you mentioned, Social Security is under the executive branch of government. The federal courts are under the judicial branch of government. And based on that relationship, essentially the federal judge is a referee looking at what the Social Security Administration did with the evidence it had. So when you get to federal court, the record is frozen. So you can't add more testimony. You can't add more medical records. It's a frozen record. At the lower levels, in front of the Social Security Administration, that's where you're doing your case development. That's where, you want to make sure you've got all your updated medical records. You want to get opinions from the claimant's treating physician to support disability. And you want to get written statements from family members and friends about the claimant's ability to function. And then you have that hearing where the claimant testifies about their pain and their problems, their limitations and whatnot. When you get to federal court, a transcript is prepared, and it includes every document that was in front of the Social Security Administration. And in addition to that, the hearing testimony is transcribed. That means it's typed up and turned into a written form. So one of the big differences between the two is at the Social Security level, you're doing your case development. You're constantly adding information to the record. In federal court, the record is frozen. Another main difference is that in a federal court case, what I'm doing is I'm looking at that Social Security judge's denial. I'm identifying legal errors. So what I'm doing is I'm looking for areas where the Social Security judge failed to essentially properly apply the case law, the regulations, and the statutes. So it's a little bit, the focus is a little bit different. In front of the agency, you're developing the case, medical records, medical opinions, claimant testimony, the testimony, written statements of what we call lay witnesses, friends and family. In federal court, I've got a closed universe, a frozen record, and I'm looking for legal mistakes that the Social Security judge made. So it's kind of a different approach, really.
Right. One of the things I tell clients is it's not just about if you're disabled or not. It's also, are there legal errors in that were done? Now, of course, it helps.
That's
if the evidence
right.
really supports disability, but it's not just
right.
about that.
Right. That's
a
good distinction. Yeah.
One of the other distinctions I'll make too, which you brought up earlier, is that in federal court, there's actually an attorney that works for Social Security, very similar to the PI cases and the workman's comp, that will sometimes write a brief that tries to tear apart your arguments in your case. So there is an attorney now assigned to Social Security to represent the judge's decision. Now, as you and I both know, some of them can be very reasonable, and they'll read our arguments and say, oh, you're right, let's remand this, right? But there's others there's others that are maybe less reasonable. So that's another distinction in a sense that there's an attorney now assigned to the other side to represent Social Security.
Absolutely.
And then the final big distinction generally is it's all done in writing, right? Generally speaking, now I think this has happened once in my career, but generally speaking, the federal court judges don't ask the lawyer to show up, give verbal arguments. They don't want to hear from the clients to give testimony, like you said, because the record's frozen. Now, have you ever been called in the United States District Court to give a verbal argument?
Out of the hundreds of cases, I can remember 2 occasions where a judge asked for oral argument. Now, again, we're talking about the U.S. District Court in the District of Oregon. I don't know if other jurisdictions have different practices where they might put more emphasis on oral argument.
Right.
But in Oregon, it's extremely rare for us to appear and make oral argument.
Right.
But we write these incredibly long briefs, 20, 30, 40-page briefs. And when you go to federal court, it's a lawsuit against the commissioner of the Social Security Administration,
right?
Which I always thought was kind of neat because, an average citizen gets to sue the head of a federal agency and hail them into court and cause them to, in effect, answer for what they've done, Right. But as you point out, the arguments are made in writing. These briefs we file are very extensive, and the idea there is, if I can't say it in 30 pages, and these oral arguments, they give us, I don't know, in the Ninth Circuit, your opening oral arguments 5 minutes, and then sit down, so, what am I going to say in 5 minutes that I haven't already said in a 30-page brief? So,
Right.
and I think that kind of the judges view it the same way, and there's just no need for oral argument with, because the briefing is so extensive.
Right. What I find interesting is that just this part of the conversation where we were talking is that, you did a ton of hearings, Social Security hearings, but had never done, and were referring off the federal court work to kind of a quote unquote federal court specialist.
Right.
And in 2002, you decided to do your own federal court work, even though you have this long, rich history of doing Social Security hearings. And I think a lot of clients or potential clients may not know that not every Social Security lawyer has the skill set to take it up to United States District Court. And then even more rare is taking it from the United States District Court up to the Circuit Court, which is the second highest court in the country.
Correct.
And then even more rare after that is having someone go up to the Supreme Court, right? So, which I don't think you've done.
No.
Correct me if I'm wrong, but
I haven't taken a disability case to the U.S. Supreme Court. That,
right.
Its appeal to the Supreme Court is not automatic.
Right.
You have to ask the court to review your cases, and it's pretty rare for them to pick up a disability case. They will tend to do that where there's a split in the circuits.
Right.
So where, let's say, the 11th Circuit has one way of dealing with certain evidence, and the 9th Circuit has another way of dealing with that evidence, the Supreme Court will pick up those cases to resolve those conflicts in the circuits.
You have a ton of experience, and what I think of it is like there's a lot of lawyers out there that do hearings. Then there's
Right.
not as many of those lawyers that have the Social Security experience that do federal court work, specifically appealing Social Security cases, and even a smaller group of Social Security attorneys that go to the Ninth Circuit. So when I think about Bruce Brewer, I think cream of the top, creme de la creme, right, of experience going through the different levels of appeals, and then I only know a handful of attorneys that go to the circuit court level that do specialize in Social Security. Because it's not like you can just hire someone who says, "Oh, we take cases to the Circuit Court of Appeals," but they don't know anything about Social Security law, right? So it is first of all, Social Security law is sort of a niche or niche area, but then it's even more niche to have a federal court lawyer do it, and then even more niche to have a Circuit Court of Appeals do it. So Bruce Brewer, you are the creme de la creme, and that's what I like to think about it.
Well, thanks, Pete. What I will say also is, so from about 1987 through 2002, I was doing disability hearings, tons and tons and tons of disability hearings. And, after that many hearings and doing it that long, you kind of feel like I've plateaued. I'm as good as I'm going to get. I've seen it all. I've done it all. I've maxed out on my skills as a hearings attorney. And I was so wrong about that. When I got into the federal court work, that requires, let me take a step back. In the circuit courts, now I can't speak to all the circuits, but I believe this is true, but within the Ninth Circuit Court of Appeals, Social Security disability law is the biggest area of law. So there's more disability cases, Social Security disability cases in the Ninth Circuit than in any other area of law. So, courts deal with criminal law. They deal with contract disputes. They deal, the federal courts deal with civil, toxic torts, all kinds of areas of law. disability is the number one area in the Ninth Circuit Court of Appeals. So there's this vast body of law, and really what I consider the finer points of law that you don't really pick up as a hearings practitioner until you get into federal court. My work as a federal court attorney has greatly expanded my ability and my skill set as a hearings attorney.
Right.
Because what I'm doing is I'm bringing in knowledge of the finer points of law as created by the Ninth Circuit. We call it common law. I'm bringing that knowledge into that disability hearing. So I'm asking, when I question a client in a disability hearing, I have certain Ninth Circuit Court of Appeals cases in my mind that I'm checking boxes, because in certain problem areas in a disability case, what I'm looking at is this kind of evidence is the kind of evidence that Social Security judges use against people to deny claims. The Ninth Circuit specifies how they're supposed to address that evidence. I'm asking questions of the claimant based on the Ninth Circuit law that, again, does an end run around what Social Security judges commonly do with certain areas of evidence. Anyway, bottom line is, I thought I kind of had plateaued. No.
Right.
Getting into the federal court work really vastly expanded my capability as a hearings attorney.
Right. I think almost every one of our attorneys, because I know, has filed at least one case into the United States District Court. I think. There's one person I have to check with. But let me kind of ask you, just kind of in line with this sort of idea of what you bring into a hearing now, because you represent clients on behalf of Evan's disability, and you go into a hearing, and then in your mind, as you're going through questioning and back and forth with the judge, you're also looking for, okay, if we lose, I want to make sure we have appealable issues, not necessarily for the appeals council, but really for a federal court. What are things that if a client is watching this, that they might expect from you on how to prepare, not just yourself, because obviously you're prepared. I kind of joke, most of my lawyers that work for the firm, we could just give them the file, a completed file, the day before, and they probably could walk in and do an amazing job at the hearing if you didn't have to prepare the client. Now, we all know we have to prepare the client. So what are things that you sort of, and we, again, a Mount Everest sort of view down to help prepare your clients that, you will walk into court with?
Well, one thing, and I do a lot of appeals for a lot of law firms. Mm-hmm. And so I read the transcripts and I see, the hearing is a recorded hearing, and it gets typed up and put into the record in a federal court appeal. So I get to see what lawyers are doing, and not to be critical of my friends in the disability bar, but sometimes it seems like lawyers don't know exactly where they're going and what they need to prove. In a disability case, we have what's called a five-step sequential evaluation process. In step 3, we're looking at whether somebody meets or equals a listing Step 4, can they return to their past relevant work based on their functional capacity? That's called residual functional capacity. In step 5, the question is asked, are there other jobs that exist in significant numbers in the national economy that the person can perform? So in step 5, we look at their age, education, work experience, also known as a vocational profile. And depending on their age, what kind of work they've done in the past, that affects what I have to prove to get to a disability decision, get to a favorable decision. So, so that's the first thing, is I go into a hearing knowing exactly what I need to prove based on their age, education, and past relevant work experience. What I tend to focus on is, what has the claimant already said to the Social Security Administration? Because in the initial application and often on reconsideration, they're filling out a form called a function report, and I call it the chores and shopping form. And it's like an 8-page form, and it asks everything from, do you go grocery shopping? What chores do you do? What social activities do you engage in? It literally asks, what do you do from the time you wake up in the morning till the time you go to bed at night? This is a very crucial form. And I do a deep dive with the clients on that form.
Before the
hearing, in our conferences to prepare them for the hearing,
right?
Because sadly, they often kind of hurt themselves. They don't, the questions aren't really designed to get at the truth of the situation. I know that sounds cynical. The questions are imprecise, they're vague, they don't ask what shouldn't be natural follow-up questions. And I think a lot of times claimants just kind of rip through those forms.
Right.
They and no fault, it's not anybody's fault. It's a 9-pager. It seems pretty, onerous to some people. And I think sometimes they kind of fly through it, and they'll tend to not necessarily say things that hurt the case, but they will say things that can be misconstrued by a Social Security judge who's looking to deny the case.
Right.
I go into that. The flip side of it is sometimes they do great function reports that really help the case, that set forth, in effect, if credited, a disabling residual functional capacity. And then that, in the hearing, I emphasize that, and I update from that, and I get clarification. So that's one of the big things that I focus on is, what has the claimant already told the government?
Mm-hmm.
Is it harmful? Is it harmful because it's vague? If it's vague, let's fix it. Let's make it more precise.
Via oral test. I'm sorry to interrupt, but make it more precise via testimony at the hearing, or are you asking clients to refill out the whole form?
No, we're at the hearing stage at this point. So we're going back and we're referencing in the hearing, we're referencing that function report.
It's like, what did you
So,
mean
I mean,
by
in simple,
sometimes? What did you mean by I sometimes garden? What did you mean by I sometimes go for a walk, or I sometimes feed a pet, or I sometimes take care of my grandkids? What does sometimes mean? And you're
exactly.
doing that at the hearing. Yeah.
Exactly.
Let me,
And there's all this Ninth Circuit case law about, you know, I mean, I'll give you an example. People take care of their kids, take care of their grandkids, right? Social Security judges like to use that fact to deny claims.
Sure.
They don't get into the details of what's involved. You know, what they do is they basically say, you take care of kids, therefore you're not believable and you're not disabled.
Right.
That's the extent of the analysis. Well, invariably, when you get into it with people, yeah, I did a hearing yesterday. She watches 4 grandkids, right? 40 hours a week. You go, how is this person disabled? She's watching 4 grandkids 40 hours a week. Let's get into that. Let's see what that involves. We've got a 13-year-old grandkid in the mix who's very responsible and helpful and is doing the cooking. Oh, well, that's a good fact to bring into the case.
Right.
The form didn't flesh that out.
Right.
The form says, do you take care of other people? The claimant writes, I take care of 4 grandkids. And that's what we go into that hearing.
Right.
Well, I explore that with the client. So, you know, in the case I did the other day, the 13-year-old and the 11-year-old, very responsible, very helpful, doing the lion's share of like the meal prep for the younger ones and things of that nature.
Right.
In that case, the claimant had testified because of her pain to needing to lie down essentially half of her waking hours. And so how do you engage in this quote unquote childcare while you're, and sometimes I tell the client, I'm going to challenge you a little bit because I know the judge is thinking this, right? So let me steal the judge's thunder a little bit and kind of challenge you. But I'm on your side. I'm here to win the case. But I might sound like I'm challenging you. I'm not really. And basically I say, well, you're telling us you're down, you're lying down, you're on the couch, you're in the recliner half the time. How is it that you take care of 4 grandkids? I already know the answer to that question because I've gone over this with the client in our pre-hearing conference, and I'm laying down on the couch, propped up on pillows. The 2-year-old's occupied with toys. The olders are taking care of the youngers. When the 2-year-old needs to be changed, the baby's brought up to me on the couch. Okay. Right. So are you still able? You told us you're down half the time. Are you in a recumbent reclined position half the time that you're taking care of the grandkids? Yes, I am. So what we did there was we went from a written statement that says, I take care of 4 kids, to the details about that activity that show not only is it not inconsistent with disability, the manner in which she performs this activity is actually more proof of disability.
Right.
So you take this thing that looks like a bad thing in the function report and you flip it and you turn it over and you make it essentially be in your favor. All that is based on a Ninth Circuit case called Treviso, where the Ninth Circuit said, hey, this Social Security judge used child care to deny credibility and to deny the claim. However, the judge had no details about how the person performed the activity, how much help they needed, how much they lifted, what they actually did.
Right.
So that's one of my big things I focus on is, I having done all these federal court appeals, I know what these judges are going to do to deny that case.
Right.
I know. And so I take that evidence, I take those activities, and we get into the details.
Right.
To show this is not an active person. When you get into the details of those activities, what you find is that they are done in a manner that is consistent with disability.
Right.
So I don't know if I answered your question.
Oh, you did. No, it's great. Let me kind of add into this a little bit. Like, I had an opportunity to do an interview with a mutual friend of ours, Dan Hyatt, who's a former Social Security law judge who now works for the firm. Right. And one of the things he said is, that surprised him as a judge a little bit was having to deal with problematic lawyers, from one who would like throw a file across the room to others who just never read the file from his estimation. And, it speaks volumes to you because you're deep diving into the medical records and the files and the forms. And then, also meeting with your clients way in advance to prepare them. Like, hey, look, let's flush this out a little bit because you've read the file, you've prepped it. And then you prep them. You prep them to go answer, to kind of be prepared that, hey, I'm going to come at you a little bit, but no, I'm on your side because I want to it's better for me to come after you versus this judge to come after you.
Yep.
And in that, you prepare the client for that. And I've heard so many stories from folks where, my lawyer showed up for the first time 30 minutes before the hearing, and that was the first time I talked to them. They did the hearing, and then they were out. And,
right.
That as we've grown, that is just my nightmare. I never want to do that to clients. My goal is to always to have our lawyers be available to them to ask, to prep them for the hearing.
Yeah.
And
you have to.
Yeah.
They tell us in law school, never ask a question that you don't know the answer to. Right.
Yeah.
And so, but one thing I'll point out, Pete, is that I will tend to have those conferences in which we prepare the client, get them ready for the hearing. I have that conference close in time to the hearing, actually, because there's a few tips and pointers and stuff. I have found that if I have that deep dive hearing prep conference a week or two before the hearing, we get into that hearing, that client has forgotten. Yeah. And, memory, people who have chronic pain, people who are on certain types of medication, people who struggle with depression and anxiety, and people, yours truly, who are getting older, right? We forget stuff. Our memories don't work the way they used to, right?
Sure.
So I like to do that conference, like typically the day before, or if I've got an afternoon hearing, I'll spend a couple of hours with the client in the morning, getting them ready. So when we get into that hearing, everything that happens, I can't literally say everything, but most of what happens in that hearing, they already have familiarity with it because I've gone over with them not only the procedure, but the type of questions that they're going to be asked by the judge, and then of course the questions that I'm going to ask. So it's kind of like we do a little hearing before the hearing.
Right.
And so when the, client, these things are very nerve-wracking. Most of my clients say that they don't get any sleep the night before a hearing.
Right.
These things are very, very stressful for people.
Right.
What I like to do in that pre-hearing conference is I give them so much information that when we get in that hearing and we go on the record and the hearing begins to unfold, the client goes, "Oh, I've heard that before. I've heard that before. I've heard that before.
All right.
Oh, that question the judge just asked me, Brewer already told me I was going to get that question. And we've already worked out an answer."
Right.
So the client, has a sense of familiarity, that they're not just lost in this, in this process or this hearing procedure that, and the stakes are so high for people, this is their life.
Yeah. Financial, some financial.
Yeah, it's their livelihood. It's the difference between, do they have a place to live?
Right. Let me, I've taken up a ton of your time here. I want to point out a couple of things. Just to, one of the questions I challenge everyone who works for the firm is this question of how do we add value to our clients? That's the core question. How do I, as an employee of evidence disability, add value to our clients, add value to our team, and add value to our firm? And one of the things I got not a ton of pushback, but a little bit of pushback is we recorded a pre-hearing conference that I would normally do with a client, which may be a little bit different than yours, and it lives on our website under client resources. The reason we recorded it was because I felt like I would do these hour-long meetings with clients just to walk them through, here's what the hearing's going to be like. Here's kind of the 5 categories of questions that, you can take all the questions and break them up into 5 or 6 categories. And then we give them sample questions on a piece of paper, give them some homework to do. And so we have a great packet that all our clients get before they even meet with you. And we did a mock hearing that lives on our website as well, that they can go watch just to kind of see the general flow of how a hearing will work. And then to kind of go back a little bit, I think it's about an hour-long video that lives on YouTube and on our website about how to fill out the adult function report. And I literally filled one out. It's very detailed. It's instructions on sort of exactly what you say, like, hey, don't just write down, I take care of the grandkids for 40 hours a week. You should be writing down, like, I get help. The kids are this age. They are able to take care of themselves. The 13-year-old changes the 4-year-old or 2-year-old's diaper. Things like that. And so if you're listening to this, jump to our website, go to the client resources tab at the top. You can find those videos. There's a whole list of videos on different forums because I talk about the work history forum as well, because I think that's probably the second most popular forum that judges use, if not the number 1 most popular forum. You and I have a differing opinion on the adult function report forum. I'm a little more pessimistic than you. And I say that in the video, like, this is my opinion. Every lawyer is going to have their own opinion. The only difference is my opinion is there's that form, from my experience, doesn't make the case, but it definitely can break the case if you don't fill it out correctly.
I absolutely agree.
Okay. I think medical records, 90% of the case of the judge's decision, if you were to take a pie and put all the evidence into this pie, and then the judge's weight, 90% of it goes to medical records. But to your point, if the judge is looking to find a fully favorable, they will use the written evidence as well and everything to support what the medical records support. But because it's taken up so much time, we can go back and forth on, the forms and how to do that for sure. Let me ask you this last question before we go. And I'm so grateful for all the time you've given. For those who are pursuing a disability claim at the administrative level, whether that app, recon, or hearing level, is there a kind of a big piece of advice that you would give them to maybe put themselves in the best possible position for success?
Now, are you referring to a client who's not represented or who is?
Sure. Let's talk to that audience. Someone who might not be represented.
Well, I don't know. Practical things. Whatever you submit to Social Security, keep a copy.
Yeah.
If it's a crucial document, a lot of the stuff's online now, and you get a receipt for it. That's fine. Fax it. If it's an appeal form, send it, return receipt, request it. Just kind of practical tips like that. In respect to the application and the forms that you complete, I don't want to sound like, I'm just saying, hey, go to Pete's website, but be careful with that function report.
Yeah.
So what happens? People go, I go grocery shopping. Well, if you look at what's involved in grocery shopping, essentially it requires a light level residual functional capacity, as that's defined by the Federal Dictionary of Occupational Titles. And if you don't say all those other things, like you never go grocery shopping alone because you need somebody else to carry the groceries, or you lean on the grocery cart like a walker. You're not just walking up and down aisles because you got a herniated disc and you can't walk that far. Or you're riding around in the electric cart at the grocery store. Or, you've got somebody at home when you pull up to offload the groceries. Don't forget those. The forms don't ask you for those details. Don't forget those details. I mean, those are the biggest. Another thing, people give up hope, okay? And they go, well, my doctor isn't doing much. They're prescribing whatever, anti-inflammatories. Doctor's not listening to me. Doctor's not helping me. So forget it. I'm not going to the doc. I'm just going to stay home. And a lot of folks, will come to you and you look in the record and there's not much there. And what I do if I undertake a case in the early stages of representation is I say, you got to go to your doctor. You got to go and you got to say what's wrong. And I always tell them, I say, don't go there because it's happened where they go there and say, well, I'm here because my lawyer thinks I should go to the doctor to build up my disability case, right? That gets charted, right? You don't want to see that in the chart. That's not good. Okay. What I tell people is when you go to the doctor, come from a frame of mind of wanting to get better.
Right.
And the reason for that is if you come from that, well, maybe they'll find something and you'll get better and life will get better for you. The other thing, though, is that if you come from that place of wanting to get better when you're going to the doctor, you're going to be detailed. You're going to give a lot of details about what's wrong. See, I think a lot of people feel real intimidated in that exam room with that doctor, and they actually need to advocate for themselves a little bit.
Right.
So you got to be clear about doc, not give up, not throw in the towel. go to the doc and say, look, hey, I was all geared up to go to the family reunion and I had a flare up and I had to stay home in bed.
Right.
Real stuff. What can be done about this? What you're doing there is you're being detailed about your pain. You're also being detailed about how it affects your function. Some of that gets into the chart. We like seeing that as disability attorneys. We like seeing that.
Right.
I have a client that says, I got pain shooting down my leg. If I do anything, I'm in the recliner half the day, right? I go look in the chart notes, not a single mention of that.
Right.
So I tell people, you got to tell your doctors how your pain and your problems are affecting your ability to function.
Right.
And you can give them little examples, and it's often what I see is missed social events. And it can be physical pain, it can be depression, it can be anxiety, it can be panic disorder. What I see is the failure the inability to follow through with plans.
Right. Right.
We want to tell our doctors about that
Right.
My condition is affecting my life to that level. That's the kind of stuff we want to get into our chart note. Because later, I go and I ask this doctor, hey, doc, what can they do? How far can they walk? How much can they lift? How much do they have to lie down during the day? This isn't the first time the doctor's heard about that stuff.
Right.
The other thing, too, is that Social Security judges, when I do get a good, favorable opinion from a treating physician, Social Security judges, if they're looking to deny a case, they'll go, well, that doctor's opinion is not consistent with his chart notes.
Right.
In his opinion, he says, hey, this person has to lie down 2 hours out of the 8-hour day and would miss work 4 days a month. The chart notes say nothing about that. Right. And they'll call that an inconsistency and they'll undermine that doctor's opinion or reason. If you're talking to your doctor about how your impairments are actually affecting your life, first of all, the doctor's probably going to come up with a better treatment plan. We're going to have better documentation of your limitations in the chart. And later, when I ask the doctor to, rate your capacity, he's going to know something about that. Anyway, that's a big overarching thing that I would tell all clients.
No, I
know I'm very long-winded. I apologize. I don't know.
It's the 30-page federal court brief writing.
Exactly.
Look, just one of the things when clients come to our firm, they get a welcome to Eva's disability packet. And in that packet, there's a checklist of things that they can do to help build their case. And on that checklist is a sentence that says, make sure to get your symptoms on record with your doctor. So often folks go to their doctor and the doctor's like, how you doing? And they'll be like, I'm okay. So when you read, I'm okay, it doesn't come across with all the flexion in your voice or the emotion on your face where like, oh, I'm okay. That's what the judge sees. They just see, I'm okay. So it's really important to get I think, a lot of times too, when people say I'm okay, what they're saying is I'm at baseline. I'm where I was the last time I saw you. There haven't been, any major flare-ups or that kind of thing. Or they forgot about it. And this is where I get a little bit, tell clients like, look, if you have a major flare-up and you're only seeing your doctor once a quarter, like once every 3 months, You may have forgotten about the flare-up 2.5 months ago. So when you do have that flare-up that puts you on the ground or in the couch or on the bed for 2 to 3 days, diary it and take a note of it when you can. And when you do go see your doctor, it's like, hey, doc, there's the last 3 months have been a bit tough. There was a flare-up, 2.5 months ago. It put me in bed for 5 days. I literally had to crawl to the bathroom, had my, niece come over and serve me food during that time. And I don't know what happened, but I wanted to bring that to, I wanted to bring that to your attention. So that's what I'll tell clients is, make a little note.
Right. There are certain cases too, seizure disorder. There's all kinds of things where frequency is crucial. How often are you having panic attacks? How often are you, having to, take a break, pull out of, family events or this sort of thing. Talk to them about your symptoms. Talk to the doctors about how those symptoms affect your daily functioning in your life.
Right. I did say I was only going to ask one more question, but I think you've already addressed this. What was your first job again, right out of law school?
Oregon Legal Services.
And that's some, and what do they do? Just briefly, they just serve the underprivileged.
Oregon Legal Services is a nonprofit organization that has offices all over the state of Oregon. They get grant money, some federal funding, things of this nature, and they provide legal services to the indigent.
Right. So basically homeless people who can't afford a lawyer.
You don't have any money, you can't afford a lawyer, but you got a legal issue and you need representation. In certain areas of law, they'll provide that representation free of charge.
Right. So as I wrap up here, I wanted to make this point because it's not something that you mention, but it's something I notice all the time. You went to a really great law school, and you went to the University of Oregon Law School. I joke around; it's definitely a top 100 law school in the country. And I joke that because we have some University of Washington law connections in my family, which was a top 20 law school, top 25. But no, University of Oregon is a great law school. You could have taken a job, almost anywhere. But you decided to go work for a legal clinic, and everything I've known about you, and I'll just share with our audience this recent story. And you're the guy who, if a client is living in the woods, will hunt him down and send him a pad to sleep on out of your own pocket. You pay for that, mail it to him, and just it's because not only. Well, I won't say this. Your skill set is the creme de la creme, but your heart for our clients and for the people you serve is so much bigger than even that. And for that, I am grateful to have known you for 23 years. And as much as trash as we talk to each other and the fun that we have and the friendships that you and I have developed over the last couple decades, it's your heart that I'm most impressed with. So I want to end on that note, brother.
Thank you.
Yeah. Well, thank you for your time. I hope we get to do this again. And I just a ton of great information for our clients to get to know you a little bit better, potential clients that may say, hey, I want Bruce Brewer, or just whoever, just pick up a knot of info. So thank you so much for your time, Bruce.
I will say this, and this is a personal thing, but when I was 18, I was in a motorcycle accident. I lost my leg in that motorcycle accident, and it is that experience that led me directly to representing disabled people.
Right.
So, when I get into a case with people, they become a friend.
Yeah.
I mean, they do. I enjoy it. I love that aspect of it, connecting with people,
Yeah.
because I get it. I get it. Yeah.
Well, thank you again. You've given me a ton of time today, some great information, and hopefully we'll get to do it again soon.
Sounds good.